Imagine opening a letter telling you that you owe $15,300 for an apartment you left 23 years ago, an apartment you haven't thought about since the early 2000s, an apartment where someone else has been living and paying rent the entire time while your name silently remained on the lease. That's exactly what happened to one woman in Oregon, and when she started digging, what she found was worse than the debt itself. Here's the full story. We need to go back to Los Angeles in 2001. A young woman, let's call her Sarah, is sharing a loft apartment with her boyfriend. Both names are on the lease. Both are legally responsible for that unit under California landlord-tenant law. She also has an infant at the time. The relationship is strained. By 2002, it's over. Sarah packs up, moves out, and starts rebuilding her life. She never looks back. Sarah says she gave proper notice when she left. She believes she told the property manager she was moving on. It was a traumatic period. Details are hazy after 2 decades, and she never obtained written confirmation that her name had been formally removed from the lease. She assumed moving out was enough. She assumed the paperwork would handle itself. That single assumption, 23 years later, would cost her $15,300. While Sarah rebuilt her life through 10 separate apartments, multiple cities, and eventually the Pacific Northwest, her ex-boyfriend Marcus stayed. Same unit, same building, same loft in Los Angeles, 23 years of rent payments all from him, and buried in the property records, never updated, never corrected. Sarah's name, still there, still legally attached, like a ghost she didn't know was following her. In 2025, Marcus contacts Sarah out of nowhere. The building has a mold problem. The property manager is covering his hotel costs during remediation, but there's a check and it has 2 names on it. His and hers. He wants her help cashing it. Now, here's the detail that changes everything. Marcus has a documented history of check fraud. Sarah's alarm bells don't just go off, they detonate. She refuses, cuts contact, and then makes a phone call that opens a door she was not prepared to walk through. Sarah calls the property management company and asks one direct question. Is my name actually on this lease? They send her a document. Her name is on it, but not her signature. Just a typed name on a page. The company had purchased the building from a prior management firm, and records had transferred without proper verification. But in the eyes of the law, a name on a document is still a name, and that document was about to be used as a weapon against her. Sarah doesn't panic. She drafts a certified letter, return receipt requested, to the property management company. She states clearly she hasn't lived at that address in over 2 decades. She bears no responsibility for the unit's current condition. They should remove her name immediately. It's the right first move. Certified letters create a paper trail. They formally put the other party on notice. And in legal disputes, notice matters enormously. She sends it. Then silence. The silence ends when a collections notice arrives in her Oregon mailbox. $15,300 for an abandoned apartment, a car towed from the premises, a unit left by the creditor's account in serious disarray. Sarah is stunned. She spent years building her credit from the ground up. She was genuinely proud of where she stood financially. And now, one letter about a loft she left in 2002 threatens to undo everything she worked for. Let's be fair to the other side. From the creditor's perspective, this is entirely straightforward. They purchased a debt tied to a lease. That lease has 2 names. Both individuals are legally responsible. They are not required to investigate who actually lived there, who paid the rent, or how long ago the other party left. Sarah's name is on the paperwork. In their world, that is enough. What would you do if a collector came after you for someone else's mess? And what about Marcus? He stayed in that apartment for 23 years and paid rent faithfully, month after month, year after year. That counts for something. But did he know Sarah's name was still on that lease? Almost certainly. Did he ever tell her? Not once. Not in 23 years. And now that the apartment is vacated and the bill has arrived, he's blocked her everywhere. His family won't respond. The man who could answer every question has completely vanished. Here is the law you need to understand. When 2 people co-sign a lease in California, they enter into joint and several liability. Joint meaning together. Several meaning each one alone for the full amount. If a landlord is owed money, they can pursue either tenant for everything owed. It doesn't matter that Sarah paid rent in Oregon, in Washington, across 10 other cities for 20+ years. If her name is on that Los Angeles lease, she is legally on the hook. But Sarah has a potential defense, and it's called novation. Novation occurs when a new arrangement effectively replaces an old one, releasing a party from their prior obligations. If the property management company accepted rent exclusively from Marcus for 23 years without ever requiring Sarah's involvement, a court could find she was implicitly released from the original agreement. It requires a legal argument. It is not automatic. But 2 decades of single-party payments is a powerful factual record. Courts notice patterns like that. There's one more law working in Sarah's favor. The Fair Debt Collection Practices Act, the Fdcpa. Federal law gives you 30 days from the collector's first contact to dispute the debt in writing. The moment you send that dispute, they must pause collection activity and verify that the debt is valid and legally yours. If they can't verify it, or if they violated the act in how they pursued you, you may be entitled to damages. That 30-day window is not optional. It is everything. Sarah's most powerful asset is her paper trail. 10+ leases spanning 2 decades, each one proving she was paying rent somewhere else, somewhere that was not Los Angeles. Every signed agreement is a timestamp. Every address is evidence of a life built elsewhere. In legal terms, this documents constructive abandonment. She demonstrably left, demonstrably lived elsewhere, and every dollar paid to that loft came from one person. It was not her. But here's what she doesn't have: a written release from 2002, no signed termination, no written acknowledgement from the property managers that she had departed. Nothing. In 2002, most people didn't document lease exits the way we do today. They moved out, assumed the landlord handled the paperwork, and moved on. That one missing document, from 23 years ago, is the entire foundation of the creditor's case, because proving you didn't do something 23 years ago is genuinely, painfully difficult. If this reaches a judge, the core question is narrow and critical. Was Sarah legally bound to a current, enforceable lease, or is her name a paperwork artifact left over from a sloppy records transfer between management companies? The creditor must produce a signed lease bearing Sarah's verified signature. So far, they have produced a document with her name typed on it. Unsigned. Courts do not award $15,000 judgments based on a typed name. That is a serious evidentiary problem for the other side. The honest legal assessment. Sarah has a strong case. Not a guaranteed win, but a strong case. 23 years of independent leases, 0 financial connection to the apartment, a certified letter on record establishing notice, and an unsigned founding document. Many consumer protection attorneys take Fdcpa cases on contingency, meaning no upfront cost to the client. She may get this debt dismissed entirely. She may even be owed damages if the collection agency overstepped federal law in how they pursued her. The most urgent front, though, is her credit score. A $15, 300 collection account appearing on her credit report could drop her score by 100 points or more overnight. But the law provides real protection here. The moment she sends a written dispute to the collection agency, they must halt all collection activity while they investigate. If they cannot prove the debt is valid and legally hers, they must remove it. Her dispute letter is her shield. She needed to send it immediately. As this story came to light, Sarah was consulting attorneys in both Oregon and California. She was compiling every lease she had signed since 2002, and she was documenting every attempt to reach Marcus, including the moment he blocked her on every platform after she refused to help with that check. That behavior, combined with his documented history of check fraud and the suspicious dual-name check, tells a story of its own, one that a skilled attorney would absolutely know how to use. This case carries a warning for every one of us. When you co-sign a lease and move out, you remain legally bound to that unit until you receive written confirmation of your release. Moving out is not enough. Verbal notice is not enough. Assumption is never enough. This is what a 23-year time bomb looks like detonated because 2 people in 2002 trusted the system to clean up after them. It didn't. It never does. Property records are messier than most people realize, especially when buildings change ownership. Ghost tenants are real, names from years or decades past, still legally attached to units they haven't seen in a generation. Every time a building sells and records transfer, stale data can carry forward unchecked. Most of the time, it never matters. Until one day it matters enormously. And by then, the one person who could have fixed it 20 years ago is blocking your calls and not answering his phone. If you have ever co-signed a lease and walked away without written confirmation of your release, go check your records. Not tomorrow, today. And if a debt collector has ever come after you for something that was not yours, drop your story in the comments. I read every single one. Our video on the Fair Debt Collection Practices Act breaks down exactly how to dispute a debt and protect your credit. Link is in the description. I'm your narrator for Courtroom Chronicles. Know your rights, protect your name, and never let the past catch you off guard.